Go back to one of our top stories now. The second docket has become a bone of contention in the Senzo Meyiwa murder trial. Advocate Zandile Mshololo, representing accused number 5, has made a special entry application to the court, saying her client was denied crucial information contained in that docket. But of course, that application she decided to withdraw. What happens in instances where there is more than one docket for the same case? To answer that question and more, I'm joined by legal expert Tyrone Maseko. Mr. Maseko, thank you very much for your time. But of course, that question is something that I think maybe even the layman would have an answer to, right? It's not usual to have more than one docket in a criminal case.
Good afternoon, Maseko. That's right. It is somewhat unusual. I mean, you can have a docket relating to different matters, sometimes involving the same parties, but by definition, those are different cases, and so it makes sense. I mean, you might have someone charged with fraud, charged with theft, totally unrelated, and they can be prosecuted separately. I guess what's interesting in this matter is, and what makes it so complex is what is the relationship between those two cases? And so it involves a fair amount of speculation. I mean, if you consider that these 5 accused are charged with murder, I guess it's fair for them to speculate as to, well, if there's another docket that relates to the same incident, what is contained in that docket? What are those people charged with? And if and so you can understand why they would think, well, we want that to be part of this case. It may very well be that it is relevant here. And that's a problem, is that we don't know if it is relevant in this case. And that's a decision that would have been made by the DPP, whether the two cases are related or not. And the problem is they don't have to justify it to us beforehand as to why they didn't combine the two cases. But there usually are good reasons why they're not being prosecuted together.
Well, in the meantime, while we try to figure out as South Africans what that good reason might be, Mr. Maseko, this trial, there's all these conspiracy theories that are making the rounds. Who's involved? Is there a corrupt hand that is involved, etc.? Why would the state hand over such a huge part of the case, docket 375, to the defense so late into the trial already? Why would they do that? Is that not an indictment on their preparedness?
No. I mean, as we were saying just now, so you have to be careful and think about it this way. As I understand it, and I guess to clarify the point, as I understand it, the second docket, and this may not have been made public yet, but I think, sort of what I picked up along the way is that it really relates to charges after the fact. So as I understand it, those accused, the intention is to charge them with being an accessory, or not an accessory, but to defeating the ends of justice. Defeating the ends of justice necessarily takes place after the commission of the initial crime and after the crime has been completed. You then, for whatever reason, do things which hinders the administration of justice, and in the opinion of the police and the prosecution, you ought to be charged with that. Now, if you think about it logically, the two cases are not related. Well, if those are the facts, there's nothing in the murder case that that is required in the defeating of the ends of justice case in order to progress that initial case. And so, because think about it, I mean, if you were to combine the case, let's assume that it is defeating the ends of justice and you combine the case. The parties who are defending themselves in the defeating the ends of justice case would literally be sitting for months and months listening to evidence that relates to a murder for which they've got nothing to respond to, they've got nothing to say to. So now you're paying lawyers for almost 3 months, 6 months to sit there not responding to any evidence because your case essentially has not begun. That makes absolutely no sense. Why? Because the evidence of the one case is not related to the other case, which would be different if they were charged with being accessory before the fact, because then essentially you're dealing with the common purpose doctrine where even though you were not part of the commission of the crime, but your participation in the planning of the crime means that we also charge you with the crime. As I understand it, there is not the case here. But so it does involve some speculation as to what is it that the other parties are going to be charged with. Yes, and that's what conflicts and makes the picture very bad, yeah.
Exactly. But, the question basically is the state giving this docket to the defense when the trial had already started, and then telling the court that the defense can use the evidence in docket 375 during cross-examination, So now, are you saying that you think that Advocate Zandile Mshololo's application yesterday for irregularities was incorrect?
It can be both. So this requires some discretion. And the problem is the application of the discretion by the NDPP is going to be different to the discretion that is applied by Advocate Mshololo. And what I mean by that is that the NDPP, when they make a decision as to whether the evidence, so the investigation of the case, remember, I mean, these charges are different. This, as I understand, it's not murder they're charged in the second case. So the evidence that relates to the second case it may not have an impact at all on the first case, the one that the murder case. And that is a decision that the NDPP would have arrived at. And if that is true, then there is no need for them to then disclose that docket, because for what purpose, to what end would they be disclosing that docket? The counterfactual, though, and the problem with it is that the NDPP might hold that view, but the defense in the murder case might hold a different view. So for them, you might have boxes and boxes of evidence in the second case, and only have maybe one statement in one line, one statement in those boxes, which the defense thinks, aha, we think this is useful for us, and all of a sudden that becomes relevant. But then is it fair on the NDPP to say, well, just because you may use a small and a little evidence in that matter, that necessarily means that I must disclose the entire docket. So it's a question of application of one's mind as to whether the cases are related or not. We're yet to see the extent of the relationship between the parties, and it's not clear to what extent the evidence has now been disclosed is actually going to be used and is useful for the defense in the matter case.
All right, Mr. Maseko, thank you so much. I've unfortunately run out of time. As a layman, I like to engage because some of these things I want to understand, especially because this hearsay evidence now in 375 has been approved to be admitted in court. So it's going to be quite interesting to see what exactly is said in that particular affidavit by Brigadier Ndlovu. That was legal expert Tyrone Maseko unpacking the drama in the Senzo Meyiwa trial for us.